I will be explaining the case of Garis and Jeffress that considers the fair dealing exceptions to copyright infringement. Mr. Garis and Matthew Moore were authors published in the Western Australian and Sydney Morning Herald newspapers respectively. Although their claims were brought separately, they cover the same issues of copyright infringement. Mr. Garis is the undisputed author and by the nature of his contract for services, the owner of the copyright of his work, Looking Past the Winners, published in the Western Australian on 10th September 1988. The respondent, Jeffress, was a press clipping business that monitored different media sources to provide photocopies to their customers. One of the press clippings taken and reproduced was Mr. Garis's Looking Past the Winners. Mr. Garis claimed Jeffress had infringed his copyright rights under Section 31(1) of the Copyright Act in the course of carrying out his business. Jeffress claimed that it fell under the fair dealing exceptions. 1. For research or study under Section 40 and 103C. 2. Criticism or review, Section 41 and Section 103A. And 3. Reporting the news, Section 42 and 103B. In order for these exceptions to apply, the court must assess if they are 1. For the relevant purpose. The relevant purpose is that of the person making the dealing, not for the purpose the reproduction will be used. And 2. Under fair dealing. Firstly, was Jeffress reproducing Mrs. Garis' work for the purpose of research or study? Research is defined as diligent and systematic inquiry or investigation into a subject in order to discover facts or principles. Under the Copyright Act, a person can copy limited amounts of copyrighted material for an assignment or thesis, articles for research, or assembling information to write a journal article. You do not have to be enrolled in an educational course or institute. You can copy for private research or study. This exception is important for the advancement and sharing of knowledge to promote education and innovation. Jeffress's purpose, which was purely commercial, is to supply a photocopy material already published in return for a fee. The possibility that it would later be used for scholarly application was relevant. Because it was solely commercial in nature, it could not be for research or study, and Jeffress could not rely on this exception. Secondly, was the reproduction for criticism or review. A fair dealing with literary work will constitute copyright if it is not for the purpose of criticism or review. The court held at paragraph 43, Jeffress's process involves scanning media for particular subjects according to the request of subscribers. It does not appear to extend to the passing of a judgment as to the merit of the articles identified. Therefore, the activities of Jeffress and the services he provides cannot be characterized as criticism or review. Thirdly, was the reproduction for reporting the news. News includes a report of any recent event or situation published in the news, radio, or television. It was held that Jeffress's business was solely of a commercial nature. The reproduction of Mrs. Garis's work was not for the purpose of reporting the news, nor was it associated with that purpose. On the element of fairness, Justice Bowman at paragraph 55 considered the case of Hubbard and Vosper, who outlined the fairness that must be assessed in terms of degree, with consideration to the extent of the extracts and the overall impression. In the present case, Jeffress took the whole of Mr. Garis's work and supplied it to customers for a commercial advantage, and not for any other purpose argued under the fair dealing exceptions. Jeffress did not comment or provide analysis of its content, and the dealing was held not to be fair. Therefore, it was held Jeffress could not rely on the fair dealing exceptions and had infringed Mr. Garis's copyright rights.